Welcome to the Deep Dive, the shortcut to being well-informed. Today we are digging into a legal decision that has absolutely massive, if maybe slightly hidden, implications for how state governments and industries too handle environmental regulations. This is the Supreme Court's recent June 2025 ruling in Oklahoma v. EPA. Now, this case isn't really about whether the air quality rules themselves are necessary. That's a whole other discussion. This ruling is purely about the logistics, you could say, the logistics of justice. Where do you get to challenge the federal government when they say your state's pollution plan just isn't good enough?
Exactly. And for anyone, running a business or involved in drafting environmental policy, knowing which courthouse you're headed to, is it your local one or the big national one in D.C.?
Right.
Well, that changes everything. So our mission today is pretty straightforward. We want to take the, let's be honest, complex legal weeds of this case, Oklahoma v. EPA, and really explain the two core principles the Supreme Court laid out. They essentially drew a much brighter line defining when an environmental lawsuit belongs in your regional circuit court, that's your local court, closer to the actual data and the situation on the ground, versus when it must go to the D.C. circuit, which really functions like the nation's regulatory headquarters court.
And the conflict here was, well, it was a perfect storm, wasn't it? Modern regulatory strategy hitting states' rights head-on. You had the EPA disapproving the individual pollution plans, these SIPs we'll talk about, of 21 different states. Oklahoma and Utah were key players here. And this was all tied to the Clean Air Act's Good Neighbor provision, which is basically the rule saying, hey, upwind states, stop polluting the air of your downwind neighbors.
Right. And what the EPA did next, that was the really critical legal maneuver. They took all 21 of these state-specific disapprovals and bundled them together. Just packaged them into one single massive rule published in the Federal Register.
Ah, okay.
And their argument was simple enough on the surface. Look, we treated all these states similarly. We use a national framework. Therefore, this whole thing is one national rule, and if you want to challenge it, you have to come to the D.C. circuit.
But the Supreme Court looked at that strategy and essentially said, hold on a minute, not so fast. Okay, let's really unpack this setup. Let's start with the basics, the air quality rules themselves. What's the backdrop here?
Okay, yeah, good place to start. We have to ground this in the Clean Air Act's fundamentals. So at the very top, you have the EPA setting what are called National Ambient Air Quality Standards, or NEAQS. You can think of these as like the national pollution speed limits for major harmful stuff like ozone. And the 2015 update made those speed limits significantly tougher.
More stringent, okay.
Right. Now, once the federal government sets that national standard, that speed limit, it's actually the states who have the primary responsibility for figuring out how to meet it. They do this by creating their own state implementation plans, or SIPs. A SIP is basically the state's detailed roadmap. Think local traffic laws, construction plans, specific deadlines showing exactly how that state plans to meet the national standard within its borders.
And crucially, this roadmap has to account for pollution that drifts across state lines. That's where the Good Neighbor provision comes in, right? Because air currents obviously don't care about political boundaries.
Exactly right. So every state's SIP, their plan, must include measures to make sure their own in-state emissions from factories, power plants, whatever, don't mess things up for their neighbors who are also trying to meet those same national air quality standards downwind.
Okay. So in this case, these 21 states, they submitted their SIPs basically saying, we think we're already being good neighbors. We don't need to add expensive new controls. But the EPA looked at each one individually and disagreed.
That's precisely it. The EPA reviewed those 21 individual state roadmaps, found problems, deficiencies in all of them based on the Good Neighbor requirements, and then issued 21 separate disapprovals. Initially, anyway.
Right. So instead of potentially facing 21 different lawsuits in 21 different regional courts, which I imagine sounds like a logistical nightmare for a federal agency.
Oh, absolutely.
The EPA decided to issue this one giant omnibus rule. They basically stapled all the disapprovals together, and they claim that this consolidation, plus the fact they used a sort of common four-step analytical process for all states, made the whole thing nationally applicable.
And that brings us right to the legal gatekeeper question the Supreme Court had to wrestle with. The Clean Air Act itself has a specific rulebook, Section 7607B1, that dictates where you file a legal challenge. It basically sets up two main buckets for EPA actions.
Okay, so what are those buckets for someone listening? If I want to sue the EPA over something like this, how do I know? DC or my local court?
Okay, bucket number one. If the EPA action is genuinely nationally applicable, think of a rule that applies identically everywhere to everyone. like maybe a new emission standard for all cars sold in the U.S. That kind of thing must be challenged in the D.C. Circuit. That's the default for big, broad national policy.
Got it. National rule, national court.
Bucket number 2.
Yeah.
If the action is locally or regionally applicable, this is the default for things that primarily affect a specific state or region. In that case, the default venue is the local Circuit Court of Appeals, the one covering the state where the action actually applies.
Okay, that sounds pretty straightforward. Local impact, local court.
But there's always a twist, isn't there? This must be where the EPA saw its opening to get everything into D.C.
Exactly. There is a critical exception, a loophole, if you will. Even if an action is locally applicable on its face, it still has to go to the D.C. Circuit IF.
Yeah.
2 conditions are met. 1, the action is based on a determination of nationwide scope or effect. And 2, the EPA actually publishes a finding saying so. This is what the EPA was banking on. They were essentially arguing, yes, okay, we disapproved Oklahoma's specific plan, which looks local, but the reason we disapproved it was based on our national methodology, our nationwide scope determination. So D.C. Court gets the case.
Okay, let's pause right there, because this is where it gets really interesting, legally speaking. The Supreme Court tackled this by applying a 2-step inquiry to see if that exception, that loophole, actually applied here. And step 1 was all about figuring out what the EPA's action truly was.
That's the absolute crucial first move the court made. They explicitly said you have to look past the packaging. You can't just look at how the agency decided to group things together in the Federal Register. The real definition of an EPA action comes from the specific law, the specific provision of the Clean Air Act that the EPA used to justify what it did.
So EPA puts everything in one big box labeled national rule, but the court's job is to open the box and see what's actually inside. In this case, 21 smaller state-specific decisions. Is that the gist of step 1?
That's a perfect way to put it, because state implementation plans, these SIPs, are fundamentally state-specific documents. They deal with Oklahoma's unique geography, its industries, its power grid, its state laws. So the court said, approving or disapproving any one state's SIP is inherently a locally or regionally applicable action. In fact, they called a SIP decision the prototypical example of a local action.
I see. So the mere fact that the EPA happened to disapprove 21 SIPs on the same day, using maybe some similar logic points, doesn't magically transform the Oklahoma disapproval into a national policy decision. It just means EPA had a busy day with 21 local issues.
Precisely. The 10th Circuit, that was the lower appellate court that heard this first, they had made the mistake of viewing that big omnibus rule as a single national thing. The Supreme Court said, nope, that's wrong. Each disapproval is its own local action.
Okay, so step 1 establishes these are local actions. That takes us to step 2 then. Did the reasoning behind these local actions trigger that nationwide scope or effect exception? This is where the new test comes in, right?
Exactly. Step 2 asks, why did the EPA disapprove Oklahoma's plan? Was the reason truly national? And this is where the court introduced what we can call the primary driver test.
The primary driver test. Okay, what does that mean?
It means that for that exception to apply for a local case like Oklahoma's to be forced into the D.C. Circuit, the nationwide justification EPA points to must be the primary explanation for and driver of the decision. That's the key phrase. And critically, the court said it's not the primary driver if the EPA also relied, in significant part, on other factors, especially what the court called intensely factual state-specific considerations.
That sounds like a really important distinction. So the EPA can use national models or thresholds to start the process, maybe, but if the final thumbs down relies heavily on specific local data points or analysis about that state, then the case stays local.
That's exactly right, and the court found plenty of evidence for that in the EPA's own rulemaking record. The agency itself documented numerous intensely factual determinations that were unique to each state it disapproved.
Can you give us an example? What kind of state-specific, intensely factual stuff are we talking about for, say, Oklahoma or Utah?
Sure, let's take Oklahoma. The EPA's final disapproval wasn't just based on some national air model spitting out a number. The EPA specifically faulted Oklahoma for things like an insufficient evaluation of additional emissions control opportunities within Oklahoma. They were basically saying, we looked at your specific industries, your power plants, your local situation, and we don't think you adequately assessed the controls you could implement right here. It's very local.
Okay, so it's about Oklahoma's specific circumstances and potential actions. What about Utah? same kind of thing.
Very similar. For Utah, the EPA's disapproval zeroed in on finding specific technical and legal flaws in Utah's arguments. And the way Utah tried to justify discounting certain emissions that were affecting air quality downwind in Colorado, again, these are really granular critiques. They're about Utah's specific engineering calculations, its legal interpretations regarding its own sources. That stuff relies on local data, local meteorology, specific factories within Utah.
So even if a national rule started the conversation, if the final reason EPA says no is because, say, Utah's engineers made a mistake calculating emissions from that specific power plant, well, that sounds pretty local.
That's the court's conclusion. Because these final decisions to disapprove were reached only after the EPA did this predominantly fact-intensive, state-specific analysis for each state, the core reasons the primary drivers were ultimately local, not national. The national framework wasn't enough on its own to force the disapproval.
Now, hold on. Because the EPA did point to some national tools they used across the board, we need to address those. They mentioned their updated national air quality modeling, right? And that well-known 1% contribution threshold they used to screen states. Didn't they argue those were national drivers?
They absolutely did. And the court actually agreed that these tools, the modeling, the 1% threshold, a couple of other policy interpretations they applied consistently, these did qualify as determinations of nationwide scope or effect. So they met that part of the test.
No.
But, and this is the crucial distinction the court made, they determined that these national tools were only acting as analytical heuristics, or maybe think of them as screening tools. They helped EPA decide which states needed a closer look, but they weren't the primary drivers of the final disapproval decision itself.
Let's use that 1% threshold to make this concrete. That's a simple number, right? A national policy. If a state's pollution contributes more than 1% to a downwind state's problem, they get flagged. That seems national.
It is national in scope, yes. Think of it like a preliminary filter, or maybe a tripwire. Hitting that 1% threshold just meant an upwind state was considered linked to a downwind problem. It signaled that further evaluation was needed. But as the court specifically pointed out, even after a state hit that 1% national tripwire, there was still a lot of work to be done. Hitting the threshold didn't automatically mean your SIP was disapproved.
Okay, so the 1% flag just says, we need to look closer at Oklahoma. It doesn't say Oklahoma's plan is automatically bad.
Precisely. The real work, the analysis that actually drove the final decision to say no to Oklahoma or Utah, was that subsequent detailed fact-finding stage. Did Oklahoma's proposed solution actually fix the problem flagged by the 1% link? Did Utah's technical data hold up under scrutiny? That required the state-by-state, intensely factual analysis. So the national tool initiated the process maybe, but the local facts drove the ultimate negative outcome.
Okay, so wrapping this up, what does this all mean for you, the listener? If you're working for a state or maybe an industry that has to comply with these plans, what's the bottom line?
Well, the most immediate impact is that the Supreme Court dramatically reinforced the ability for these challenges to be heard in the regional courts, closer to home. They reversed the 10th Circuit's decision. Challenges to the Oklahoma and Utah SIT disapprovals must now be reviewed in their own regional circuit court, the 10th Circuit in this case.
Right.
And the bigger takeaway, I think, for anyone dealing with federal regulations is that courts now have a clear instruction. Look past the packaging. When a federal agency bundles many local decisions into one big rule, maybe for efficiency, maybe strategically, the key question is, what was the real reason, the primary driver, for the final decision on your specific issue? Was it genuinely a broad national policy application, or was it ultimately decided by those intense, detailed, state-specific or local facts?
It feels like the court is really sending a message about accountability here. That even with big national environmental goals, the specific factual details matter, and they should probably be reviewed by courts that have a better handle on the local context. If the core dispute is about a flaw in Utah's specific engineering report, maybe the 10th Circuit is better placed to understand that than the DC Circuit.
I think that's a fair reading. It definitely creates a strategic puzzle for agencies like the EPA going forward. If they want future multi-state decisions reviewed centrally in DC, which is often seen as promoting national consistency, and frankly is usually easier for the agency logistically.
Sure.
They now have to be much more careful. They need to ensure that the rule's final justification truly hinges on broad national policy, not just a collection of local findings wrapped in a national bow. They can't just slap a uniform framework on top of what are essentially local disputes and expect the venue to automatically shift to DC.
It seems like this ruling demands more substance behind the claim of national applicability. They have to be genuinely national in their reasoning, not just in how they package the paperwork. Which does raise an interesting final thought for you to consider. If an agency's decision relies, say, 90% on local facts unique to a state, and only 10% on a general national policy or screening tool, how could they ever successfully argue that the national part was the primary driver needed for a DC venue? Where is that line now? Something for you to mull over.
Yeah, it's a fascinating intersection of environmental law, administrative procedure, and fundamental fairness. Definitely one to watch.
Absolutely. Thank you for joining us for this deep dive into the Clean Air Act, the EPA, and the Supreme Court.